Welcome to episode number 2 of Staff Lawyers Claim Your Rights series. My name is Neil Fishman. I'm the founder of stafflawyer.com. On this video, we are going to discuss for United Nations international civil servants and other employees of the workforce of United Nations entities such as World Health Organization, World Trade Organization, and many others. We are going to discuss the concept of what is an administrative decision. This is a concept and question that comes up frequently for staff members when they find themselves facing a grievance with their employer. So let's get right into it. How do we define an administrative decision? Well, according to the United Nations Appeals Tribunal and Dispute Tribunal, an administrative decision is a unilateral decision taken by the administration in an individual case which produces direct legal consequences. According to the ILO Administrative Tribunal, an administrative decision is any act by an officer of an organization that has a legal effect. So what does that mean? Those words of legalese mean quite simply that an administrative decision is something that has a direct impact on you. It has to be final, and it cannot be just merely a suggestion. So, for example, a decision to abolish your post is undoubtedly a unilateral decision taken by the administration that impacts you and has direct legal consequences. So we can distinguish between administrative decisions and other types of acts by an international organization. So at the beginning, an important question to ask is, when does one need to challenge an administrative decision? And the most important provision to highlight to you is that you must check your organization's rules. Every organization has different rules, and each of their rules will set forth the timeline in which one needs to challenge an administrative decision. They do tend to vary. Some organizations require one to challenge within 30 days. Others require a challenge to be lodged in a longer time frame, such as 60 days. And finally, please take note of the fact that discussions with your supervisor or with the person who took the administrative decision does not necessarily toll the deadlines. So if you need additional time, you need to make sure that the body that will be reviewing the administrative decision has specifically granted to you in writing a decision that allows you to have an extension of time. There are important exceptions to deadlines. The first exception is a new decision. When a new decision is taken, it supersedes the previous decision. By superseding the previous decision, you have a new decision that you can challenge in accordance with the applicable timelines of your organization. However, please bear in mind that confirmatory decisions, which are in essence just decisions that have agreed with the previous decision, which are identical and which have not examined new issues, do not provide you with a new timeline. So it's important to be able to distinguish between a new decision and a decision that merely reiterates the same rationale on the same issues as a previous decision. Where should you challenge an administrative decision? Again, check your organization's rules. The staff regulations and staff rules of your organization will set out and explain where a staff member needs to challenge their administrative decision. You can also look at the administrative procedures of your organization on grievances. They will oftentimes tell you exactly where you need to submit your administrative decision. In practice, such challenges often go to HR. Other times they go to the head of an agency. In certain types of decisions, such as those related to committees or related to misconduct, oftentimes they can be directly appealed to an internal appeal body or court, but in each case, you need to check your rules first. Another important question is, must an administrative decision give reasons? Generally, the answer is yes. However, not always. And why I say that is because an administrative decision in accordance with the ILO-AT Administrative Tribunal requires enough information so that you can decide whether you would like to appeal. However, the reasons don't need to be very detailed. They can be quite generic, and then they can be elaborated on at a later time when you challenge the administrative decision. So what oftentimes happens in internal appeals is that a decision that is very short, that might only be justified by 1 or 2 sentences, when it goes up on internal appeal, the organization then has to disclose the evidence and true justification for why the decision was made. And in that case, if the justification is somewhat different than what you were told, or if there's more evidence provided to you during the internal appeal, you have a right to provide observations on that additional justification. I'd like to also highlight to you the ICSC standards of conduct, which are important and impact on all individuals employed by UNA entities. And under the ICSC standards of conduct, it says that it's incumbent on managers and supervisors to communicate effectively with their staff and share information with them. Another important topic is, can I challenge a rule change? The answer is yes, but only when it's directly applied to you. What this means in principle is that, for example, when an organization is in the process of creating a restructuring process and a new staffing plan, until that staffing plan has been approved and has been applied to you, you can't challenge it. So there are cases in front of these tribunals where individuals have challenged a draft staffing plan, for instance. In that case, the request is going to be dismissed as being premature because there has not yet been an individual administrative decision. Another important question is, are retroactive decisions legal? Generally, they are not legal. Decisions cannot have an adverse impact retroactively on staff. However, there are instances where decisions can be made that do in some way impact on you with a retroactive impact. An example of that is a recovery of overpayments. When staff members are paid more money than they are entitled to in accordance with their contract, the organization is allowed to recognize that error and then go back and recover the funds. When deciding whether a decision has a retroactive impact, it's important to ask yourself the question, has this decision affected a negative change in my status, rights, or my obligations retrospectively? You can contrast that with a rule that changes the way one of your entitlements might be calculated in the future. So, for example, in accordance with your organization's rules, you may be entitled to home leave. However, even though you have a right to home leave, in the future, the organization could make rules that change the way that home leave is calculated. That is perfectly legal. However, if you have already accrued a right to home leave under the previous rules, the new rules should not be able to diminish or take away from a home leave entitlement that has already been accrued. Another question that comes up when people discuss administrative decisions is, can I challenge a pay slip? And we can go through and ask ourselves the same questions that we have done earlier in relation to what constitutes an administrative decision. So, is a pay slip a unilateral decision? You bet. It is a decision by the organization taken to pay you a certain amount of salary for the work that you've done. Is it an individual decision? Absolutely. Your pay slip is specific to you and to no one else. Does it have a direct impact on you? Of course it does. And is it final? Yes, of course it is. So if your payslip has been wrongly calculated, you can challenge the wrong calculation and the rules that resulted in the calculation being less than it should have been. Finally, an important question that comes up when people talk about administrative decisions is, can I challenge the organization's bias against me? And the answer to that question is yes, but no. Yes, you can challenge their bias, but no, you cannot challenge it simply by saying the organization's biased against you. What you must do is isolate individual administrative decisions that were taken against you and that were infected by bias. Now that's easier said than done because the burden is on you and not on the organization to show bias. So you need to find circumstances, evidence, and proof of bias. How to do that? Because oftentimes, bias is concealed and direct evidence may not be available. So consequently, the tribunals have established that the proof of bias may be inferred from known facts. That is, facts that you can prove with evidence, not mere suspicions. That concludes our discussion on what is an administrative decision. If you like our video, please like and subscribe to them and leave a comment.